So we appreciate you here. We're here to do a quick overview and answer some questions that you might have about the proposed local rules. We had a little subcommittee with myself, Judge Sheldrick, Judge Banfield, Commissioner Sasser, and our court administrator, Cheryl Stone, and we did a deep dive into our local rules. Sort of broke them up. We each kind of had our little section that we worked on and then came together. And these are the proposed local rules. I will put in the chat, in case anybody doesn't know where to find them, the link on the Superior Court website. The deadline for giving us your official comments is coming up. I believe it's June 6th. Let me see, June 5th. So please get us your comments. The link for how to get the comments is on that website that I put you there in the chat. We have Judge Banfield here. She'll give a quick summary of the proposed criminal rules. I'm going to give an overview of some civil rules and our administrative rules. And then Commissioner Sasser is coming on, and she will present on some of the family law guardianship rules. I believe that Judge Sheldrick is still on docket and may not make it, but she worked heavily on that stuff. So the other thing I would note is that our plan is to meet with the criminal procedure group next week to speak specifically to the criminal rules, but we certainly welcome questions today. Maybe Jesse, if you can monitor the chat for us and let us know if there are some questions that we should address a little more quickly than others. So with that, I'm just going to launch into my PowerPoint, and then we'll have Judge Banfield go. So let me make sure I can share my screen, and I can do that. All right, can everyone see my screen? It says proposed local rules. Is that a yes? Hopefully that's a yes. So this is what I'm covering: the administration rules, our general rules, and our civil rules, but not all the civil rules, because Judge Sheldrick and Commissioner Sasser will address specifically family law and guardianship probate issues. So the process that we used in general included looking at Snohomish County, King County, Pierce County, and Spokane County's local rules for some ideas. We also looked at what's changed since COVID-19, whether it's doing a lot more e-filing, e-signing, and remote appearances. The Supreme Court has specific provisions in place with its emergency order that is still in effect, but when that goes away, which we hope will at some point, our emergency will be over, then we need some local rules to help continue with some of the practices that we've gotten used to. So what you will see in the proposed administration rules is that there's a number of rules concerning internal governance of Superior Court that are being deleted. And we're removing those from the local rules, at least that's our proposal, and making them more into internal policy rules. For example, how do we elect our presiding judge? How do we elect our assistant presiding? What's the description of responsibilities for presiding, assistant presiding, court administrator? The local rules have very tight deadlines when you can amend them and the process for amending them. So we hope by creating this more as an internal policy, it gives us a little more flexibility on internal governance. A couple other highlighted changes. We have the attorney provision on attire, professional attire, and attorney check-in on dockets. The updates really just are to comply with sort of current standards. The idea with checking in on dockets is that if you have multiple dockets that you're handling, a lot of attorneys are on multiple Zoom dockets. We're asking that you check in with the docket so that the judicial officer knows you're going to be present, maybe you're going to be late, just so we know that you are going to appear. We also are revising Rule 0.8 on the civil bench warrant. We're proposing that that language clarifies that a person who's arrested on a civil bench warrant is booked and released prior to the next court hearing. A couple of bigger general rules that are coming in, and we might have some questions on this one. I know there's been a few comments. So let's talk about the local general rule 19 on remote appearance. This proposed rule uses a lot of the language that currently exists in the new criminal rule 3.4. So it essentially says that some of that language now will apply across the board. And that is that it provides some standards and procedures for remote appearance. It confirms that unless a court or the department requires in-court appearance, remote appearance is permitted for the civil motion docket, but any party may request an in-person attendance. And of course, the court has discretion to require in-person attendance. But this essentially creates a standard for what is remote appearance and when is it applicable. Any questions about that? I know we had one comment where someone was confused about whether this would change the criminal rule that currently exists, and no, it would not. The language is specific in the proposed local rule 19 that says that it, except as otherwise provided in other rules, this is the standard. The other general rule that we're proposing is mandatory electronic filing and an opt-in e-service option. So this would allow the use of digital electronic signatures by judicial officers, parties, attorneys, witnesses, and law enforcement. Right now, this is already in place because of our Washington Supreme Court's emergency order. So we are taking that and we're saying that's something that we'd like to continue moving forward and having. It also mandates that all attorneys are to e-file unless they specifically opt out. There's also an option for self-represented individuals to opt in to e-filing as well. There is an exception to certain documents will still not be able to e-file, and that's specifically listed in the proposed rule. It also gives the option to do an electronic ex parte process. Our clerk's office has indicated that they're not ready for this right now. As many of you know, they are in the process of transitioning to OnBase, and that's a very large project that they're taking under right now. So even if we adopt this rule, we probably won't be implementing ex parte, electronic ex parte in the near future. Hopefully we'll get there soon, but that's a wish list for now. It also indicates that working copies are going to be electronically submitted to departments via a department-specific working copies email folder. This will hopefully alleviate the different departments having different procedures and policies on whether they want paper copies or electronic copies. We also want to eliminate the burden on our judicial assistants of getting a bunch of emails clogged into their email box by having a designated email folder for working copies. And then there is a permissive opt-in option for e-service between parties. And it is a may, it's not a shall, but it does provide that if you do opt in, then you need to make sure that your WSBA email address is current, because that is considered the designated email address for e-service, because our clerk's office does not have an e-service option with its software. Again, that's an issue that the clerk's office might be able to address in the future, but this rule provides for it as an opt-in. Are there any questions so far that I should be answering? I don't know, Jesse, is there anything in the chat?
There's nothing in the chat that I could see. I thought of a question actually about the mandatory e-service. Is there a timeline for registering for that? I know sometimes that can take a stretch of time. I've helped out-of-town attorneys figure out how that works. Does the clerk's office ready for that and to have a anticipated timeline?
So I think you mean the e-filing, registering for e-filing. Yes, that is going to be a challenge. The clerk's office has already alerted us that there's a backlog with the county IT department, our information technology department, on getting those registrations turned around. So obviously we recognize that it is what it is. Our goal is to try to get everyone to be registered, but we will, if this is adopted, I'm sure we will need to work with the clerk's office in the county on having some leeway on when that can actually be accomplished.
Thank you. There's some more questions in the chat. Crystal Lambert asks, is it opt-in per case or per attorney?
It's per case.
And there's a longer comment about from Meredith McKell-Graff. She is about credit card information at the clerk's office, asking if there's a way to do it. I assume the filing fees by check or something like that.
So that's another issue that is really decided by our clerk's office. The court does not have, as you know, the clerk is a separately elected official. And so the fees and how to process fees is an issue that's addressed through the clerk's office. And of course, you attorneys are all customers of the clerk's office. I encourage you to reach out to the clerk's office if you have any requests, suggestions, or you want to see certain changes to their processes and procedures. I will go, oh, go ahead. Is there another comment?
No, I was just saying thank you because there are no more comments so far.
Okay, well, I will add one other comment that we got from the family law bar presentation, which is how does this rule, local general rule 30, interplay with general rule 17 declarations? And I'm still waiting to understand why, if any attorneys want to pipe in, I'm not clear why we need a general rule 17 declaration with our current emergency order that's in place with our Washington Supreme Court. But it's my personal view, and one that I would want to confirm, that this rule, if it were implemented, would eliminate the need for a GR 17 declaration. And the reason is that the language specifically says in the general rule 30 that a digital signature by any party, witness, attorney, law enforcement officer, or judge has the same effect as a wet signature, as an original signature. So in my mind, that would eliminate the need for a GR 17 declaration. But I did want to clarify that point. Okay, we made some minor suggested changes to the local civil rule 40, which cases do not have scheduling orders. That rule now mirrors the language that's in the proposed state rule on scheduling orders. We made some minor changes for clarity on the case scheduling order. And this is for civil cases, not on family law cases, but for civil cases, some minor language modification. And then we made some minor changes to the arbitration rules. We added a special rule on extreme risk protection orders. We added some special language on civil contempt. And for our mental proceedings rules, these are civil commitments, we are allowing for remote appearance. So that's it for me. I don't know if we have Commissioner Sasser on the call yet, or if we want Judge Banfield, if you want to go ahead and do your criminal rules next. But my part's over. Thank you. Oh, and thank you, Ms. McKell-Graff, for your clarification on GR 17. I don't think we need to do that, but that's just my personal take on that. Thanks.
Judge Banfield, do you want to do your overview on your criminal rules?
Yeah, mine's super fast, so
Great.
I'll just go really quickly. I don't know if anyone's had time to see them. I don't see that many criminal attorneys on the call, but there weren't that many changes, and it sounds like they weren't well received, the ones that we had. But the changes that we did do, the purpose of the changes were to try to have some timelines in place, because there was a lot of complaints regarding I know that both the defense bar and the prosecutor's office wanted to change readiness, which was not something that's discussed in these criminal rules, but because they aren't having enough time to get to everything. I know the court was wanting to have all the pretrial motions heard prior to trial. And so this was trying to set up a space or a type of program so that we could do that. But so there wasn't much that changed on there. You can see under probable cause hearing rule 2.4, it just goes through when you can do remote proceedings and what the what you need to have to do the remote proceedings. You must have to be able to simultaneously see, hear, and speak. And so you can appear remotely as long as it's allowed by the rule, but you have to have access to the right resources to do so. And the attorneys might need to have ability to have confidential communication with each other. So that's just something that's kind of mixed the rules that are going throughout the state from the Supreme Court and through other jurisdictions. Rule 4.5 was the omnibus hearing. It looks like that was redacted out. So that's that portion was redacted out. So that's the change there. Sorry. Rule 7.8 was added. And I'd love to have anyone from the prosecutor's office comment on this, but I just know while there was not a specific policy or procedure for how those were going to come in and when they were going to be addressed. And oftentimes it seemed as if they got lost on the desks of judicial officers. And then when we'd get them, there'd be just like an email saying, hey, can you respond to this? So it was trying to set out a timeline, and the timeline themselves aren't important. The dates, the times, that's would be great for comments, but the procedure is what it was looking for. So here, discussing 7.8 motions that often get confused with other types of appellate motions. Once one is received, it just kind of laid out the timeline. It says that unless the court, once they receive it, decides that they want the matter to go to the Court of Appeals as a personal straight petition, then otherwise an order to show cause will be granted. That doesn't mean that you actually have a hearing. It's so that it can kind of just start getting calendared and everybody knows that there's a timeline for this, for the action to occur. So it says the moving party shall submit a proposed order to show cause together with any working copies if represented by counsel. Of course, unrepresented don't have to, but it's encouraged. Regarding a hearing date, it indicates that, and sometimes some people commented this was too long, some people thought it was too short, but as accepted otherwise set forth in this rule or shortened by the court, the show cause hearing shall be set forth for a date not less than 45 days after the date of the motion is filed. It's not that there's actually going to be a hearing. It's just, again, it's like a placeholder so we can make sure that the issue is addressed and the responses have occurred. So that said, responses and replies shall be filed and served not less than 15 days before the set for the show cause hearing, and replies shall be served no less than 7 days before the date set for the show cause hearing, unless.
You want me to share my screen with the rule?
Oh, sure. I don't have any, I cannot share my screen.
You can keep talking.
Okay.
I'll pop it in.
Thank you. So the whole idea of this hearing for the 7.8 is specifically to just make sure that these 7.8s aren't getting lost on either the prosecutor's desk or judicial officer's desk, that they're being addressed, and that there's a specific person who's responsible for each part. So sometimes the defense is filing 7.8 or the defense counsel, but a lot of times they just come over from the institution, they land on somebody's desk, and a lot of times they're handled via email, like what's going to happen and not happen, and it kind of catches us off guard. And I guess maybe Mr. Bartlett can speak to that, because this is where it was handled when I was at the prosecutor's office, and I know that there needed to be a procedure back then. I don't know if you can unmute Mr. Bartlett if you have any comment that you'd like to make on that.
On that particular thing, that I didn't catch exactly what you wanted me to comment on, but I do have questions on the proposed rule. That should I hold off on that? No,
go for it now. There's only like 3 rules that we had rule changes on, so I'd prefer to hear now.
Okay, so a couple of questions I had regarding, well, it says order to show cause as the option if the court doesn't transfer it to the Court of Appeals. I was wondering 2 things related to that. One, is there still going to be the requirement that the defendant make a substantial showing that they're entitled to relief prior to setting the show cause hearing? And 2, under the general rule 7.8, criminal rule 7.8, there's the other option of setting an evidentiary hearing if needed to develop the record in order to determine whether relief needs to be granted. So I was wondering if both of those things were still contemplated by the local rule, the
Yeah.
substantial showing and the possibility of an evidentiary hearing.
Yes, and so then maybe there, you can give us some better wording for that, but yes, that's exactly we're requesting. The court has to look at that and decide whether they actually need a hearing, so that's the substantial. And then after that, the courts to decide whether if oral arguments are necessary or if there's evidence to be presented. So if that's not captured in the wording of the rules sufficiently, then that would be great if you have anything that you want to offer on that.
The other question that I had was with regard to the setting of the timeline. And I understand the need to have kind of a more structured timeline. I don't think anybody can deny that it would be helpful for everybody to have reasonable expectations about when things are going to need to be filed, responded to, decided, all of that kind of thing. My question is whether the date set not less than 45 after the motion has been filed, if that's the best way to look at it when the motion is filed, or when the court determines that a substantial showing has been made to set the future hearing.
All right. That makes sense.
Just because it might be 1 month before the judge makes that determination,
Right.
then the timeline's not helpful because we don't know when the show cause hearing is going to be set.
I totally agree with what you're saying. And so again, so most of this rule came from another county because they were having the same issues as this county. And what you're saying is exactly the thing that I was trying to fix, is that like it shouldn't sit on a judge's desk for a certain period of time. But what you're saying is for you guys to have that time, it needs to have a date from the date the court decides that this actually needs to be addressed, and that there's been a substantial showing. So I appreciate that as well. So if you are commenting on the comments, if you want to put in something that you think will explain, will be better wording to explain that, that would be great. We originally had used a lot of terms that that others didn't necessarily like. That was kind of like the Court of Appeals. So or in the federal courts, when something comes in, so when they determine whether or not there actually needs to be a hearing, whether or not there's how we're going to make a placeholder there so that we know that, what was the term we used, Emily? Gosh, sorry.
Note for consideration.
Yeah, note for consideration. So that's what we were trying to grasp, but other judicial officers didn't really appreciate that wording. So if you have wording that you think will prevent the time from passing before you guys have an opportunity to actually look at it, by the time it gets off a judicial officer's desk, whatever, we'd appreciate hearing that. So those are all good responses.
Right. And I would say for ease of our procedure, Mr. Bartlett, if you could put those comments in our website comment form, it's the best mechanism for us to review those comments and look at them carefully. So if you wouldn't mind doing that, that would be a great help for us.
I did plan on submitting comments, but this question and answer session is helpful for me to, I guess, formulate what those comments are. So that's why I haven't yet. May I ask another question?
Yes, please.
So the hearing that's set, the show cause hearing that's set, is a determination going to be made at that time, even if, say, so the responses come in based on the schedule that's been set, the show cause hearing happens, there's been no request for an oral argument. Is a decision on the merits going to be made?
Yes.
Okay, and so thank you for that. At that point, I think that there'd be no consideration as to whether we would be moving to transfer the motion to the Court of Appeals as a personal restraint petition, because once there's a merits decision, the court can deny the motion on the merits, and then they can directly appeal that decision. So, I was just asking that question because I was curious about the response may take the form of a motion to transfer the defendant to the Court of Appeals for consideration. If we're hitting merits decisions at these hearing dates, then that won't be the response.
Right. Well, as you can see, there's two places for that, because hopefully the judicial officer will first see that this should be moved to the Court of Appeals when it first arrives. But yeah, anyway, I understand what you're saying, and we need to.
Just as a further comment, those would be what our response. That would be our response if we were doing a preliminary response before the merits hearing or show cause hearing that was determined. And then the final question I had, thank you for allowing me this time, is the show cause hearing that's set, if we want the oral argument as this rule contemplates, is that oral argument going to happen at the currently set show cause hearing or calendared for another time?
Calendared for another time.
Thank you.
So those are all, those are great. And I'm not actually taking notes on what you're saying. I'm getting ready to jump right back into trial. So you could make sure you write all that down. That's the kind of information we were looking for when we did these.
Thank you, Judge.
Okay, so we can move on to the next area, which is, oh, you already did it. Scheduling of motions. This was the one that got the most comments. And so again, the whole idea behind this, and this was taken from, I believe, either Snohomish County or another county of similar size, was to try to get these motions set ahead of time so that judicial officers they were getting frustrated by the lack of pretrial motions prior to trial. And the times listed that are on here, they're all in parentheses. The reason is because we're not set on the times, not set on the times for the briefing, we're not set on the times for the motion, or when everything has to be set. But the whole idea is to get these things set ahead of time. A lot of the comments that came from the scheduling and timing of the motions were that, you know, the prosecutor's office would be penalized because they weren't able to get certain things at a certain time, or it could be manipulated. And from the defense was, there's no way this can happen because the prosecutor's office isn't getting their discovery to us or anything ahead of time. So the idea was to meet everybody's needs to try to like start at omnibus or at arraignment, not at omnibus because that's way too far, but at arraignment or sometime soon, if you know that your case has these issues, to try to get something on the calendar. One of the other responses that we saw was that currently there's not a manner that the judicial assistants don't have any available dates at this time already, and so in a perfect world that would not be the case. They would be able to set these motions. What we're hearing from them is they would like to have these set ahead of time. So if it's not practical, that's one thing, but if you find value in the scheduling and timing of motions in the rule, or if you find no value, I mean, I guess that's what I should ask for the prosecutor's office. Are you finding no value in the scheduling and timing of motions? Anyone?
If
Go ahead.
I may, Judge.
Yes, please.
First of all, I understand the need for having a lot of these motions that are listed ahead of trial, and I agree with that. The one that I had a question on is the 3.5, the CR 3.5
Right.
hearing. So I was just curious, is the main impetus for this like not wanting to waste the jury's time? And the reason I ask is because in my experience, prior experience in trials, as your experience as well, I think most of the time they were done like the morning of trial. Yeah. And typically it's going to be like a 15 to 30 minute hearing, and it's not going to be dispositive, I'd say 99% of the time.
Yeah.
And we can usually fit it in like between a morning break, or even like, when we send them to lunch or whatever. So I'm just curious so that, I can formulate my comments, and our office, frankly, can formulate our comments.
Yeah, I agree with you
for this.
Yeah. We always did those ahead, mostly the 3.5s. We did those a lot of times ahead of time. I guess the hard thing is we're talking about what we are doing currently and it's not working, but that has a lot to do with COVID and everything else, and and how many cases that everybody has at this time. But yes, the complaint from judicial officers is that they would like to do these things ahead of time so that this part's taken care of and the jury's not sitting there, which has been happening frequently. So that's why they're asking that. This is in response to their need to be able to start moving those trials and getting them going right away and not have a jury waiting. So
I think if I could add, and I can stop sharing if we're done looking at the rule. I think the other issue is we're trying as much as we can to have more consistency in departments in practice. We're looking for a procedure that attorneys can rely upon and know that this is what to expect when I go to trial. This is how it's going to work. Having different departments with different procedures, I think, is a challenge for our scheduling and the jury waiting is a big issue. So we have a limited amount of time available, and we're trying to use our jury time most efficiently, especially during COVID times with people sitting in a room all together. We're trying to minimize that when we can. So those are some of the ideas, but we're open to ideas. I would say our hope, our goals, we're open to hearing suggestions.
And I think one of the things that's happened is a lot of these pretrial motions that we've been seeing, we've had actual like motions to suppress statements that were going to be, that would have been, that would make it dispositive, or, you know, certain evidence that would come in that would actually change the way the whole case is presented to the jury. And the judges have been frustrated by that at the beginning, when at the day of trial, learning of these issues. And, you know, motions to suppress at that time as well, filed by defense, which makes sense. So, but they want to hear these matters ahead of time so that we can just proceed with trial at that time. So if you have suggestions around that, then let me know.
Just, may I follow up just briefly? Yeah. It's kind of a follow-up to actually what you said before I asked my questions, and that was, and it caught my ear, to address these at arraignment and or omnibus as far as scheduling these hearings. Is the court prepared? Because I wouldn't want to lose, you know, statements obviously in a case. Is the court prepared to schedule, you know, a 30-minute, 1 hour, 3.5 hearing for every single felony case that has statements on it at arraignment?
I don't, well, so I mean, that was one of the comments that had been made earlier. No, of course, they're not going to want to do that for every single felony case. Most of your guys' cases don't go to trial. So that's not the case. I guess the whole idea is for people to look ahead at their cases and kind of know what's needed in those cases. And that's what they've found has been happening. The cases have been dismissed at the last minute, because of all kinds of issues, lack of being able to get a witness in, or what other different issues that would have been resolved had there been a pretrial motion. That's the take on these. Now, you're right. I mean, the question is, these are rules that are being proposed to try to fix the timing issue. However, will these actually be, will the rest of the bench, the entire bench, want to support this? Because will they want their judicial assistant scheduling these? Is there a mechanism with which to do this? We're just trying to find a baseline to start so that we can start moving cases and have everything go smoothly. But right now, logistically, could it work? I don't know, Dan.
Well, we also are going to hear from our consultant very soon on how to more efficiently handle, we hope, our dockets in general. And so I know other jurisdictions handle these types of hearings very differently because their trial schedules with their judges are very different than how we have it set up. So it could be that we're trying to put a Band-Aid on something that's really a bigger procedural issue for how we handle jury trials. But we do welcome the comments.
Yeah, that's the truth. That's it. And if you have better suggestions, I mean, these went out for before we did these, we asked people to comment on their local rules if there's any changes that they wish that they would desire. And one of the only comments that we got from the criminal side was from defense counsel, and it was a really good comment, which is like, most of the time they get their the response to one of their motions from the prosecutor's office less than 24 hours. So they'd like it to note how long that they should be able to have the response from the prosecutor's office. So we're trying to get a very consistent timeline for people to get these matters turned into the court so we can have the turnaround. So if you have better suggestions, and I know you guys have a really good brains over there, that would be great for you guys to go ahead and send those over.
Thank you for letting me ask questions and comment.
Thank you for commenting.
So with that, should we move over to Commissioner Sasser? I know there's several family law attorneys on the call that would probably really appreciate hearing that presentation. And again, just a reminder, please do submit your comments, including suggestions for future rules. We're welcome to hear that as well.
I'm also happy to sit here quietly for 30 minutes while we discuss criminal rules. Either way is fine with me. Okay, I know that some of these folks were at our family law section on Wednesday, so I'm going to be doing the same PowerPoint presentation from that. So before I start, did anyone have a specific question on any of the family law rules? Because I don't want to make you sit through the same presentation you saw on Wednesday if you just have a question. Okay, this is Judge Ritzinus's beautiful PowerPoint, which I'm going to try to share my screen on this now. Is everybody seeing this PowerPoint?
Yes.
Great. Okay, wonderful. Let me see if I can figure out how to click through it. Okay. All right. Okay. So I put in the chat a link that gets you to the proposed local rules, the current local rules, and the link to comment on the survey. Did everybody see that in the chat?
Yes,
Great.
I posted it too.
Okay. I just want to say we really value comments. Comments are absolutely reviewed and discussed. We look at every one of them. I would encourage everyone, if you have any questions, concerns, ideas, to send them in. And we appreciate those comments. All right. Going to go through the ones that I think are most applicable. One of the ones that I really want folks to look at is the new proposed residential schedule. We received a lot of comments on this on a family law survey that we did about a year ago. There were comments with frustrations about the rule, and so we updated it to provide some, not only better clarity, but also to reflect more accurately what the commissioners are doing on the dockets. This is for school-age children. It's not a long-distance schedule, and it's an update on what we had before. It's intended to reflect both what we're doing, the discretion of the judicial officer, and what we believe best practices are. It is not blanket. It is not mandatory. I'm not going to say, and I don't believe any of the other commissioners are going to say, this parent is the primary parent, therefore the other parent will have this. We are looking at every case uniquely, but we find that some guidance on where there's clearly a primary parent and clearly a secondary parent, this is hopefully will be helpful for the parties and for the court in moving things along more efficiently. So we would be looking at 6 to 8 overnights per week, per month, generally an expanded weekend kind of schedule, and then 2 to 3 hours every other week for what's commonly referred to as a dinner visit. That's not currently part of the local rule. It's commonly requested and ordered. Summer schedule change would be adding 4th of July as a 48-hour block. Another change would be winter break, moving the transfer date to 12/26. After a discussion amongst the judicial officers, we feel that exchanges on December 24th or December 25th in high conflict cases are probably not child-centered, and that December 26th is a better date. Spring break adds in updates to match the alternating weekend schedule. Transportation would provide for picking up transfers to happen curbside at the home of the parent with the children. All right, I'm going to just keep clicking through just to the things that I think are most relevant. This provides under, again, in a family law matter, both parties can use a declaration in lieu of testimony, which syncs with our general order. Also clarifies that for all support issues, we must have financial declarations, we must have child support worksheets, and we must, in parenting cases, have the proposed parenting plan and information filed by both parties. On this rule, we had some comments and some argument about some attorneys felt frustrated if commissioners were not allowing argument. This rule is put in place to both clarify that the court has discretion. And so the court is not always going to allow oral argument. We're a pleading state. And so the court may allow oral argument, the court may not. The court has discretion. In addition, in the survey from about a year ago and in the comments we've received, parties, or rather attorneys, were bringing up the point that it was not clear to them when and what length certain submissions were allowed to be and the timing on those. And I regularly hear some of those arguments on the docket. So this is intended to clarify the length and the of those submissions and consequences for failure to comply. Continuing on, prohibiting filing the same document pleading multiple times, which we do see sometimes. Setting rules on motions for enlargement, again, setting consequences for failure to comply, and clarifying that submissions of professionals must be authenticated. Where I think folks will really want to take a look is when you're looking at your response materials and your reply materials, looking at that, we've attempted to clarify, again, the length and the date on those filings. And there's even a chart in there that gives some examples. And so you can look at that chart. On presentation of orders on family law cases, looping in the requirements of these other civil rules requires attorneys to confer before entry of orders, encourages self-represented parties to incur, but doesn't require. encourages written objection prior to the hearing, and allows sanctions for less excessive delay in presentation of orders. I think from the bench perspective, what's frustrating from us is if it appears that the orders are actually agreed, but the parties haven't nailed that down, or where parties haven't conferred at all, and then it's challenging to get those orders entered. So attorneys are required to confer before presentation of orders. This is a major change that family law attorneys need to look at. Rule 4.1G, this is going to be an automatic discovery order that will be issued at the time of filing, similarly to the way we have our automatic temporary order issued. This is going to require discovery and disclosures to be completed in cases involving support, financial declaration, a verified statement of assets and liabilities, health insurance information, and income documentation for 6 months. This isn't intended to cover all this possible discovery. Parties are not prohibited in any way from conducting additional discovery, but our hope is that this will move the discovery process along faster in cases that are contested, or especially in those self-represented cases, to get that information provided. The petitioner is required to provide that information 45 days from filing. The respondent is required to provide it 45 days from service. It provides for sanctions for noncompliance. As folks may know, Civil Rule 26I is under review, and it addresses that issue and provides some definitions of what parties are able to provide. The parties are bound by this upon filing for petitioner upon service for respondent. You must file a proof of compliance, and there is a provision for a written waiver of compliance allowed, and that's in the proposed rule. Going on to LCR 7, proposed orders. The issue is when you're parties can file orders marked proposed, but when you're presenting an order for entry, please just remove proposed from it. It's cleaner and it's clearer when those orders are entered. Under revision of a commissioner's orders, this clarifies that the standard of review is de novo. It confirms that the review is based on the record below. It specifies what's to be included in front of, to go in front of the judge. And so one of the comments that we really heard is that there needed to be a little bit more clarity on who needed to provide what the standard of review would be, and what the judicial officer who was doing the review would look at. And so our hope is that this rule has clarified that process. I drafted a new local rule for our truancy process. It's pretty self-explanatory. I'll let anyone look at it if someone's interested in that. We've updated some of the provisions with regard to guardian ad litems. This is now encompassing court visitors and guardian ad litems because there's been a major statutory change with regard to guardianships and calling them court-appointed neutrals, defining what a guardian ad litem and a court visitor are, and defining our registry. Specifies how they're appointed, specifies how they're placed on the registry, and then discusses that they're required to provide any complaints or grievances from other jurisdictions when applying. We have a committee that hears complaints about a guardian ad litem. This specifies a little bit more about that process and requires court administration to maintain files on guardian ad litems. Guardian ad litems must have a signed order of appointment, or court visitors must have a signed order of appointment before work, must have pre-approval of any additional hours. All fees are always subject to court approval, and goes over the process for being paid. So anyone that's working as a guardian ad litem or a court visitor should review that process. It goes over the process about any complaints. Complaints must be filed within 6 months of discharge. As I said before, court admin has to maintain the file. Our guardian ad litem committee, of which I sit on and a couple other judicial officers sit on, we make the additional determination. The standard is fundamental fairness that we have to follow. After the initial review, we'll either determine decline to review or whether it has potential merit. I'll note that if a guardian ad litem or a court visitor is actively serving, the committee will not get involved at that point. That's to be forwarded. Any issues are to be brought in the form of a motion or as otherwise specified by the rule in front of the assigned judicial officer. This is talking about when the guardian ad litem report has been completed and they've been discharged, the process for a complaint. Okay. All right. Does anyone have any questions at this time? Okay, I'm trying to make my screen big again.
You want to stop screen sharing?
Yeah, I do, and I can't get to the tab that'll let me do that. So yes, please. Let me see, I'm playing around with it, but there we go. I think I'm getting there now. Okay. All right, does anyone, was I able to get my, were you able to stop that, Judge Sheldrick?
I think you did. I
Okay,
didn't
great.
do anything.
Wonderful. All right, does anyone else have any questions about the rules I just went over or other questions? Okay, well, I put in the comment or in the chat again, the link to go and do additional comments and to review over those rules. I'm happy to sit here for another minute or two if anyone else has questions, but otherwise I believe that completes our presentation today. Judge Sheldrick, did you have anything additional you wanted to address?
Nothing for me, just encouraging people to take a look at the rules before a deadline passes, which is June 5th.
Yeah, comment period is open till June 5th. And then at that point, the bench will be reviewed, the local committee will be reviewing all the comments. It'll go back before the bench. And then at that point, it would, anything approved would go up to AOC for approval. Remind me, Judge Sheldrick, I think they would become effective September 1st. Anything
Right.
that's approved. Okay.
So between the comment period and when we're sending it up to the Administration Office of Courts, we may not adopt all the rules. We may modify them somewhat based on the feedback that we've gotten. We may delay implementation of some of them. So there is some, it may not look exactly the way you're seeing it right now because we might hear your comments and take it to heart and make some changes.
Any final questions from anyone? I'm happy to take that now if you have one. Going once, going twice, going 3 times. We've completed our Q&A session for today. Thanks so much to everyone for being on today. We